Anything else you want to add on this, Ms. Davis?
No.
Okay. Now, we're going to ask for public comment on this issue only. I understand a lot of people want to talk about a lot of things, but we're taking these issues up in the order of the matrix. I have 4 requests to speak, and because this is the first time we're going to do it today, I'm going to go through some of this stuff. Mr. Peterson, you had asked to speak about reduced reliance, not this item. Just a suggestion, folks in the audience who do want to talk, in the future, if you could code it to the matrix list, then we'll be sure not to get confused on the issue. And then, Ms. Mazzarella, you had wanted to talk on the Bethel Island issue, which comes up later. Then, Mr. Rentz, was to the motion that we'll consider, I think, either later today or tomorrow on the process from this point forward. I know you'll talk on other issues, but correct? Okay. So, Mr. Zlotnick, you had nothing, but you may want to talk on this, please.
Thank you, Mr. Chairman. I put nothing because it's just in case everything, I guess, right?
Not at this presentation on this item.
No, not on this item. No, this specific. And it's actually a very specific question. Appreciate the discussion and the staff's efforts to try to figure out a way to deal with everything that they could, and this 2% understand that's sort of an outlier. The concern I have, or question I have really, is for Mr. Stevens in terms of his description that, and I pardon me if I put words in your mouth, but essentially what I thought I heard was that the expectation would be that the 2% would likely, I'll use the phrase, escape covered action jurisdiction because there wouldn't be a significant impact. I think that's what you said.
No, actually what I said was that we wouldn't have any basis upon which to make that judgment now because they'd have to go through the CEQA process. They may not rise to the level of significant impact. They may.
And so is that significant impact under your covered action analysis or under their other CEQA analysis?
Well, the CEQA analysis is a significant impact with regard to the environmental effects. I'm talking about the cover. If we were to, what we're trying to do with the administrative exemptions is figure out whether categories of proposed projects have significant impacts to the co-equal goals.
Right. Okay. And
so
which is under the definition of covered actions.
Which is under the definition of covered
So my question is that the new language that you've proposed, and I believe it's item 85 in the consent matrix, says that significant impact is defined by assessing the effects along with past, present, and foreseeable future activities. And so if it's cumulative on that, affecting the co-equal goals, and you've indicated that that impact can be positive as well as negative, if I recall correctly, and assuming, for the sake of argument, that the Bay Delta Conservation Plan will be moving forward, it seems that anything in the Delta that's combined with that foreseeable activity of BDCP could be considered significant, cumulatively.
Yeah, well, we can talk a bit, again,
just sort of a question on how that works.
Mr. Stevens.
Yeah, I mean, the issue of cumulative that Ms. Gray asked that we talk about and pull off the consent, that particular change, just to be clear, and we'll jump way ahead, is really a technical drafting change. The issue of cumulative has been in the previous drafts, and I think that you and your constituents have brought it up before. But I think it raises really a philosophical, fundamental question about why this board is even here and why the Delta Plan has been charged with taking a comprehensive view of ecosystem, water, flood, and Delta as a place actions. And that is to make sure that it all fits together and you take a cumulative, comprehensive view on these important Delta issues. So the argument that you shouldn't be taking a look cumulatively at issues that, when you add them all up, are of importance to whether or not you achieve the co-equal goals is really a policy philosophical discussion that I think was already dealt with in the Delta Reform Act. So the technical issue that Ms. Gray asked that we pull off the consent item is really a drafting error that we had identified on our own. Your constituents, and I think rightly, have raised the issue before, but the issue of cumulative is the same issue of significant impact to the co-equal goals is obviously different than significant impact to the environment. but the bodies of law we've borrowed from in appropriate cases. The issue of cumulative impact under CEQA is there.
No,
I know that. Joe has spoke on numerous occasions about putting this package together and what the intent of the drafters was.
I understand that. I think we should wait till we get to item 85.
No, and that's fine, but I wanted to raise this because I think you're absolutely right. It is a philosophical issue, and I think the argument can be made that by looking at the definition of whether something's a covered action or not, which you're talking about now, whether exempting or not, that by utilizing the cumulative approach can arguably, and again, it's a philosophical question, but arguably you're taking out that significant impact criterion from the covered action analysis because in essence the argument is everything would be significant. So that just want to raise it and further discussion.
Greg, just so I understand the point of your comment, are you suggesting that we shouldn't have an exemption for temporary transfers, or that there should be no qualification for those transfers that are temporarily exempt, or is there some other point that you're hoping we can respond to?
Well, no, it was just in the conversation, the implication was that this 2% is, you're covering 98%, it sounded like, and that this 2% would not be a problem because they wouldn't necessarily rise to the level of a significant impact. Yeah. And then the definition of significant impact with cumulative in sort of begs that question. Well, and that's all I'm putting out.
Because I would just want to make it clear that the state and federal water contractors who you represent, their one-year temporary transfers will all be covered by this language. I just wasn't understanding what you were wanting us to do.
I appreciate that.
Thank you.
Yeah. So I just wanted to put that out there.